Good evening, everyone. My name is Ron Harris. I'm a legal economic historian at Tel Aviv University Law School. My main research field is the history of the business corporation, and I guess this is why I was invited by Rui and Nathan to chair this meeting of the series. I would like to thank them for initiating and organizing the online seminar series and for inviting me to chair it. I'm delighted to host today, as part of the International Macroeconomic Histories online seminar series, Cihan Artunc. Cihan has joined the Department of Economics at Middlebury College in 2019. Before that, he completed his PhD in economics at Yale University in 2014. I know Cihan since his days as a PhD student at Yale, and I'm delighted to chair this panel. Cihan's main research interests are economic history, law and economics, and he studies the role of legal institutions in the historical development, economic development of the Middle East. Today, he will present his paper, Legal Origins of Corporate Governance, Choice of Law in Egypt. Cihan will talk for about 40 minutes. Thereafter, we will be having some 20 minutes for Q&A. If you have any questions, please use the Q&A function of the Zoom in order to ask the questions in writing. If you have any clarification questions during the talk, feel free to raise them in the same way, but still noting the fact that these are clarification questions so that I'll be able to intervene if needed. So we'll be running all together for about an hour. Unfortunately, today we cannot stay beyond the 60 minutes because Cihan has some teaching commitments immediately following this talk. So Cihan, the floor is yours.
Okay, thank you so much for that very nice introduction, and thanks everybody for Rui and the other folks at the CEPR for organizing the seminar. So I'll get right down to it. In this paper, I'm going to visit this classic question of legal origins, which asks, are laws originating from the common law tradition more effective in promoting financial development than those derived from civil law traditions? This thesis is quite comprehensive. It spans many different dimensions of the law, like corruption. But really, when you get down to it, its central argument relies on a key view in the corporate law literature that the protection of minority shareholders and outside investors from the sort of entrenchment or empire building of the insiders is crucial for financial development. And the legal origins thesis then argues, well, the English law tradition, because it promoted this extraordinary legal flexibility, it allowed the incorporators to take advantage of this flexibility, adopt rules with stronger protection to attract external financing. And as a consequence, these companies could pull capital from a wider population, leading to wider ownership structures and more active stock markets. So there are really two questions embedded in this debate, whether stronger investor protection promotes organizational efficiency, and then whether Anglo-American laws promote a stronger investor protection than French law. So this question generated enormous debate, some taking cross-country analysis of laws and legal tradition and doing this top-down comparisons of statutes. But more recently, there's been a really exciting research that really focused on the histories of individual countries, trying to figure out what incorporators actually write. And for example, my esteemed discussion leader here, Ron, has written one of these papers with Tim and Naomi Lamoureux. And that paper, as well as another paper by Aitchison, Campbell, and Turner, really inspired me to take this project, because I really wanted to also investigate the choices, like what the incorporators were actually doing. But here's the issue: we want to compare countries with different legal regimes, so sort of like a cross-country analysis, right? But law cannot be disentangled from country-specific histories. So these histories are bundled together, and that's a challenge for us. Case studies are great, but now we can't compare different laws or companies under different legal regimes. So what we need is some sort of a setting where we can compare corporations in the same context using different legal traditions. So this is where my paper comes in. I contribute to this debate by taking advantage of a rather unusual setting in the context of Egypt between 1887 and 1914. So ostensibly, at the outset, this was a civil law country. It adopted transplanted French law in 1875, but the legal environment provided a really extraordinary flexibility to companies. Incorporators, because of these treaties that Egypt and the Ottoman Empire, of which Egypt was sort of like nominally a part of, they could incorporate this founders could incorporate under Egyptian law, and this was the French transplant, a close French transplant, or they could incorporate under British law, or really any European law, any European country with which Egypt had these treaties. So this allows me to trace incorporators' revealed preferences over different company laws and over different governance rules in the same institutional context, subject to the same aggregate economic shocks, and trying to really attract capital from the same credit markets. Furthermore, Egypt is like doing these things, like trying to attract a lot of investment, and it's succeeding because it received a tremendous amount of European investment and migration, enjoyed a really big boom period during this point, like right before World War I. Of governance could be really relevant because it's in many ways there are this is a place where policymakers have to grapple with promoting corporations to mobilize capital, but they're also really worried about the deleterious effects of limited liability in a large setting. All right. Okay, so what do I do in this paper? I essentially take advantage of this setting to answer three questions. First, what law did founders actually choose? What are the predictors of these choices? And I find that really founder makeup is most important, right? If most of the founders are British, that company is more likely to incorporate under British law. If not, then they are more likely to incorporate under Egyptian law. Industry at the outset looks important, certain industries, but that is spurious to essentially, that can be explained away by the makeup of founders. That seems to be like the biggest factor. Second, what kind of rules that these founders actually wrote under each legal tradition? Well, I find that each group essentially converged on a different sets of rules. British corporations had weaker voting rights, they had weaker oversight, and the directors had more extended borrowing powers. There's somewhat more entrenchment of the directors. But French corporations were weaker in other dimensions. What kind of dimensions? For example, they were less likely to circulate the annual financials about the company. They made it a bit more costly. Elections were more staggered, and elections of the directors. And so this is not like a monotonic relationship between, like the British corporations are always bad or the French corporations are always good. The comparison is a little bit more nuanced. Finally, I asked whether this sort of investor protection led to better outcomes for the firm. And I do find that these weaker protections were associated with shorter duration, so worse survival outcomes, less profitability, and lower market-to-book ratios. Okay, clearly the choice of law is going to be endogenous, right? So how do I deal with that? I try to take advantage of this shock, essentially. So there is this really extraordinary choice of law going on, right? And in 1907, there is a pretty big financial crisis. This is the global financial crisis that led to the creation of the Fed also in the United States. So this is a big crisis, and after that, many corporations go bankrupt. There's a bunch of lawsuits, and sort of the Supreme Court of Egypt, which was actually staffed by Europeans, by the way, Europeans and British people. They overturn choice of law. They say, okay, you can no longer do this. Any new corporation have to incorporate under Egyptian law. So what I do is essentially use this shock, right, then use propensity scores to construct a representative, a sort of like more believable, credible comparison group after 1908. The intuition is that these corporations, after like founded after 1908, after the repeal, would have incorporated under British law if they had that choice, okay? And then I estimate accelerated failure time models to study firm survival. I do panel regression analysis to think about some other annual firm outcomes. And I compare these outcomes across in the full sample and the match sample to make more meaningful comparisons. Okay, so let me talk about briefly some of the key institutional features here. First of all, this European, like this choice of law thing was not something that is like under the hood. It's not a furtive thing. This thing had institutional support. This goes back to actually my previous research about legal pluralism in the Middle East. And, you know, like all these there are like 15, 16 consular courts in Egypt with staff with judges and magistrates. I mean, like they are very well trained in like how to deal with these issues. And like this system has been going on for a while. There were many laws available, okay? But in practice, people use Egyptian law, which was the French transplant, British law, Belgian law, and French. Any European law was available in theory, but these were the ones that they chose the most. There was the important difference between the Egyptian law and the origin law, the French law, was that, well, the French at this point have general incorporation. Anyone can form a corporation, granted they satisfy certain requirements. In Egypt, you have to get a permission from the government. But at this point, it is not like an authorization system where, you know, like it's not like some sort of costly process. The approval is automatic, it is quick. We can see that with the data where the delay between applications and approvals are quite short. And like this is also, you know, supported by the more anecdotal evidence, perhaps, where the British governor is saying that, oh yeah, like we just approve any corporation, or rather the Egyptian government does. Okay, the second important point here is about the boom of 1904 and 1906. So this is the period where Egypt receives enormous amounts of investment. There are many corporations being founded, and people are mainly speculating on land companies and mortgage companies. This resulted in the financial crisis in 1907. There was a pretty much like this credit shock, right? A bunch of firms go bankrupt, like really almost half of the firms. I mean, it's really a kind of a disaster. Egypt enters a recession after that. Following these lawsuits, the courts see that, you know, well, okay, there are all these British companies, the shareholders are trying to sue the directors. Directors keep like taking the, you know, saying, oh, you know, you can only sue us at the British court for a British company. This is like, you know, this is unacceptable. And the courts say, okay, you know what, like we're shutting this down from now on. You have to go through the official channel. You have to become an Egyptian corporation if you are primarily operating in Egypt. Okay, what does the government do? The government doesn't do much because like that, you know, the colonial, I mean, Egypt is a sort of semi-colonial setting under British occupation. So the government country doesn't have a lot of, you know, discretion about what it can do, but it does start tightening the authorization process, which used to be automatic and quick, becomes a lot more arduous after 1914 with the outbreak of World War I. And that's where I stop my analysis. Okay, so this paper relies on assembling data on governance rules, firm histories, founders, for essentially the universe of corporations established between 1887 and 1913, 1914. And this was really, I mean, I'm really excited to talk about it, but it's also, I have to say, like really laborious work. And it involves going to many different archives to get different corporations, you know, from their, to get their charters from different archives. I mean, it was just a lot of work. So let me briefly talk about that too. So first I started with a list of corporations ever founded. This was published in 1907. And then I tracked down the charters in each sort of laws publication methods, right? In Egypt, every corporation charter, because it's a piece of law, have to be published in the newspaper, in the official newspaper. So that's how I got the Egyptian corporations. And then going forward from 1907, I was able to just use the newspaper, the official newspaper, Journal Officiel, in order to get all the charters for Egypt. For Belgium, I use Monitor Belge. And then for the British corporations, I consulted the National Archives, their sort of company record series, BT31. Okay, for the exits, I had to make sure that these were genuine exits, right? These are not sort of reorganizations and things like that. And so I used the rule that essentially the Egyptian government followed. This is the general meeting votes to wind up, okay? And so I collected these from the company records and also the official newspapers where they have to announce their like these general meeting votes, and also like track them down from like other sources using like statistical yearbooks to make sure that each exit is an exit. Okay. I also collected data on the founders from the charters and business directories to collect information about their nationalities, their residence. From the statistical yearbooks, I collected data on security prices and dividends. And overall, we have 111 British corporations, 118 Egyptian corporations founded before the repeal, 48 corporations founded after the repeal, and then 13 Belgian corporations. There are a few French corporations too, but they were all like founded before 1887, and I was not able to get their data. Okay, so this is what the sort of, you can see the frequency of corporations here. The solid line denotes indicates the total number of corporations, and the dashed line distinguishes the British companies. And you can see like there is this like really big boom starting roughly around 1902 and like really peaks around 1906. And then after 1907, there's a crisis, and so the sort of the pace of firm creation slows down quite a bit. And then the vertical line here, the vertical red line indicates the year 1908, after which the practice of choice of law is prohibited. Okay, so why incorporate under British law? I start with these observations that the contemporary press and the consular staff stressed, and they said essentially, look, people are doing this because they want British capital, they want British shareholders, and the best way to do that, well, the shareholders in Britain, they don't want an Egyptian company, they want a British company. So that's why these firms are, incorporating under British law. And I think that's a pretty sort of reasonable argument that the consular staff is making. The second one is that, well, perhaps like the British founders just prefer British law because they're already in Britain, perhaps, and they just like know this law better, and they just want to operate in something that they're more familiar with. So at the outset, in terms of capitalization, the British companies and the Egyptian companies before 1908, they're a little bit different, but not that different. You see the capital distribution here for the red line denoting British law, British companies, and the dashed lines are denoting the Egyptian companies. After 1908, yes, Egyptian corporations are smaller, and that's likely an impact of just credit drying up after the 1907 crisis. Okay. In terms of sectoral differences, I don't see many effects. Okay, so these are essentially the British corporation share by sector. We have construction, manufacturing, trade, transportation, finance, mining, utilities, land and hotels, and tourism. And the bars represent the 95% confidence interval. There are not really statistical differences in terms of like the British share of corporations in each sector, except in mining and utilities. Mining is dominated by British corporations, and utilities are dominated by Egyptian corporations. There are sort of idiosyncratic reasons for that, but these are actually explained away by the fact that most of these mining companies are exclusively British founders, and that's sort of what's driving selection into British law in this particular sector. And this is what I mean, essentially. These are the histograms of founders by nationality, right? So you see the number of British founders, number of European founders, number of local founders, and then the proportion of British founders at the very end. So I want you to focus on the proportion of British founders here, just to summarize all of that information. And you can see that if you look at the companies that incorporated under Egyptian and British law, like 50% of them like didn't have any British founders at all. And if you look at the companies founded under British law, but again, like 45% of them had exclusively British companies. So there is this sort of bifurcation that we need to worry about. So what do I do here? I follow essentially this algorithm to find out the most predictive variables of incorporating under British law. The algorithm is a forward selection procedure that starts from an initial model with an intercept term and no other covariates. And then at every iteration, I add a predictor that gives the most optimal information criteria if that predictor is included in the model. If no predictor improves the information criterion when added relative to the previous step, then the algorithm terminates. So in this case, the variable selection procedure picked the proportion of British founders, the proportion of founders living in Britain, the natural log of authorized capital, and the pound sterling dummy, by which I mean whether the company issued shares in like quoted in pound sterling or francs or Egyptian pounds and stuff like that. Specifically, the algorithm did not pick any of the industry dummies, likely again because almost all of these mining companies had exclusively British founders, and most of these founders in utilities were non-British. So you can see the table here. This is a balanced table. First, we have the full sample comparing the variables that the variable selection model predicted, and in the last column you can see the results of the selection model. And again, like there are these important differences between these samples. So there's clearly a selection into British law derived by like these observable factors. Okay, after that, I use essentially the variables from step one, right, to calculate propensity scores based on the logit regression of the treatment. The treatment being whether you're a British company or not. And then I impose a common support condition to sort of discard all these extreme firsts with no suitable control, like British companies with all British founders, they are discarded. So this allows me to construct 3 match samples where every Egyptian company is matched to the closest British corporation. We have the first sample, like my most preferred sample, which is that British corporations are matched to Egyptian corporations founded after 1908. This is a very nice interpretation. These are the firms that would have likely incorporated under British law if given the option. But there is also a problem here, right? Because you might argue, well, like post-1907, it's a very different world because this is after the crisis. We know that these corporations are much smaller. So maybe you're not really comparing apples to apples in a way because, like this is just like a different cohort. Okay, so I take that, I take that critique. I also construct another match sample by matching British corporations and Egyptian corporations founded before 1908. Okay, so this is a better like a like-to-like comparison, but now I do have to worry about the fact that, well, okay, we are now matching, like I'm finding Egyptian corporations that look like British corporations, but at the end of the day, this matching process does assume that, however, like the unobservables behave like the observables. And we do have to worry about that. Well, these corporations at the end of the day chose not to be British. So, the interpretation, I think, is not as nice as the post-1908 case. Anyway, completing the balance table now using my preferred match sample of post-1908 Egyptian corporations and the British corporations, we find that, this is a pretty good comparison where, we have a similar proportion of British founders, similar proportion of founders in the UK, and their capital also looks pretty similar. At the cost of, I dropped from 277 firms to 50 firms. So all my work of collecting this data, I had to discard. Okay, so what do I do next? I am going to now essentially calculate, to evaluate the determinants of governance rules, where I run these regressions where we have a dummy variable, which is whether the company is incorporated under British law or not, and then a bunch of corporation level controls like the capital at startup, the proportion of British founders, the proportion of founders living in Egypt, and also a public corporation dummy. And then I have industry controls as well. So in every regression, there are controls for industries. Do not worry. Okay, so these are the main governance rules that I investigate. I start with the voting rule, voting rights, how like sort of to measure the voting rights that shareholders have, and I capture that with two measures essentially. One of them is a voting rights index that Eric Hilt invented for his 2008 paper at the JEH. And essentially, I don't have time to unfortunately like go through the details of the index, but think about as the index gets closer to 1, we are now moving into a world of like 1 share, 1 vote, whereas an index that is closer to 0 means closer to everybody, each shareholder gets 1 vote. Okay, so you should think about those extremes that way. There's also, I also like do another sort of like a more straightforward control, which is a fixed voting scale. So whether the company had a rule like 1 share, 1 vote with no cap on the number of votes that can be cast. I also investigate whether any number of like whether the company follows assigned the rules that said like, oh, we're going a quorum in the general like a fixed number of people is going to form a quorum in the general meeting, like 3 members, 4 members, whatever. Instead of like scaling it with the amount of like this representation of share capital. Other rules that I investigate, whether more than 20% of the share capital is needed to call an extraordinary general meeting, whether directors receive a fixed minimum remuneration, idea being that if they don't have skin in the game, perhaps they're not disciplined correctly. I investigate whether the first board of directors, which is appointed during the firm's creation, is not fully rotated, so there's some degree of entrenchment. I investigate whether directors' borrowing powers is not restricted in any way, and by which I do mean any way, like they don't even have to consult the general, like the shareholders, or there's not even like a rule that says, oh, you can only borrow up to like the share capital before you go and ask the shareholders or something like that. There is literally no like restriction. And then finally, I also investigate whether the annual balance sheet and like these other financials are not mailed to shareholders or not published in any newspaper circulating in Egypt or London. Here, again, weaker protection is going to indicate a value of 1. Okay, so what do I see here? We see that in the first column, you have the full sample. In the second column, you have the max sample. Here we are looking at British firms and the post-1908 Egyptian corporations. And whether you look at the full sample or the max sample, we see strong effects here where the British corporations tend to have, right, a higher Hills index, about 0.6 points. They are much more likely to have a fixed voting scale, like 1 share, 1 vote, about like in the max sample around like 80 percentage points, which is quite a lot. They are much more likely to have fixed, like a fixed quorum rule. And for the, in terms of calling extraordinary general meetings, they are not different. Minimum director remuneration, they're not different. They discipline sort of directors equally in terms of pay. About board elections, the comparisons are not robust. But we see another important point here about restricted borrowing. British corporations much more likely, or rather much less likely, to include any restriction that directors could exercise on their borrowing. And French corporations or like the Egyptian corporations were also less likely to send their annual financials to the shareholders, but this is not precisely estimated in the mass sample. Comparing the British corporations to the Egyptian corporations founded before the repeal, we find similar effects. Although now the Egyptian corporations behave a little worse in some dimensions, like they make the extraordinary general meeting harder to call, and they definitely do not send their annual financials to the shareholders. So in these dimensions, the French corporations do adopt weaker protection rights. So I have about 10 minutes left. So let me go through like some of the other things that I've done. These results are not really driven by like acquisitions and mergers. So like thinking about like the 1907 crisis hits, some firms do dissolve, even though they don't have to dissolve, they do wind up in fear of like the courts might go after existing firms as well. Okay, so what did firms do? Or like think about acquisitions and mergers more generally, which I could track using my data. There are not a lot of firms in the end, we have like 16, 17 firms that dissolved and then formed again as an Egyptian corporation afterwards. But we do see that they do like tend to adopt stronger voting rights when they reorganize as an Egyptian corporation. Okay, and this is what this table is showing. Furthermore, I can also do, I'm sure this the table is a little small, but you can find the details in the paper. But like the noise that I want to make in this table is essentially, look, we can also do one more mesh sample where I'm only restricting my matching to a subsample where only looking at, like corporations that share a founder, basically tracking the repeat founders that sort of like appear in many Egyptian corporations and British corporations, and then adding dummies for each founder as well to figure out maybe like there are some like controlling for idiosyncratic things about these founders. Maybe they prefer certain rules, right? And again, we find that the results are quite robust. British corporations much more likely to, adopt weaker rights surrounding voting, quorum rules, or borrowing. Okay. How do these rules affect firm outcomes? I investigate three things. So, the data is great in some ways and not great in other ways, right? So I don't have like a lot of detailed information about the financials, so I can't really create these like awesome, financial ratios and leverage and things like that. So I have to rely on a few other things, and I hope I will be able to convince you of the efficacy of these measures. One of them is survival, right? Survival, there's a very large literature about how incumbents are usually, more productive, like they are by basically applying the idea of like survival of the fittest. So these were firms are able to like weather the market shocks. They're able to come like stronger. And, these are the sort of like survival is a noisy but good indicator of some sort of latent productivity. Right. So that's what I'm going to investigate, especially and in two ways. First, duration from entry up to 20 years, and then duration from the onset of the financial crisis, basically April 1907. I also investigate do panel analysis on a few other yearly firm outcomes, where I investigate whether the firms paid any dividend at all. I could look at the actual dividend amount as well, but that is actually not a great measure because that could depend on many other things and not just like firm profitability. But firms could only pay dividends, and this is specified in the charters, in all of the charters, if they turn some profits. So they had to clear a bar of making enough profits before they had to pay dividends. Okay, so that's why I investigate whether a corporation did pay these dividends in a given year. I also investigate market to book value because I have the share prices and I have their paid values of these ordinary shares, so I could calculate this ratio. I include many controls here, so whether the firm is a public company, whether it's listed in the London Stock Exchange, whether there are like these things called founder shares, the proportion of British founders, the proportion of founders living in Egypt, not necessarily Egyptian founders, the paid capital each year, and also a firm's age. What I find is that this is a survival function, right? This is the full sample, and this is a max sample. And what you see is that these are the British corporations, the red curve, and they are just, they just have a higher death rate compared to all these other French law corporations. The difference between these two Egyptian cohorts are basically driven by differences in their capitalization, okay? And we see a similar story for survival since 1907. After the onset of the panic, you see that it starts a bit similarly, but then especially looking at the match sample, British corporations just have much higher attrition. I do want to emphasize that this is not driven by the proportion of British founders or something like that. If anything, corporations with British founders are more robust, and you can find some of these regression results in the paper that I circulated. We can find these results are robust to just like going through estimating failure time ratios. You read these variables as saying, look, if you have a fixed voting scale, these corporations are about 65% have 65% shorter duration. If borrowing is not restricted, these corporations have about 55% shorter duration. So we see that this difference between the frailty of the British corporations and the Egyptian corporations is mainly driven by these governance rules about voting rights and oversight over, or the lack of oversight over borrowing. Okay, let me zoom to dividend payouts. Here I'm investigating whether the firm paid any dividend at all, and these are only public corporations, not private, just public, between 1907, 1901, and 1911. And we do see some evidence here that like fixed quorum rules or voting rules are associated with worse payouts. This is a little mixed, public corporations, there are not many of them, okay? But I do want to emphasize that the results are not really driven by what's going on with the private corporations. Okay, what about, I can extend the data because I have the data on dividends for all corporations after 1908. So just a shorter time frame, but looking at 1908 to 1911, I do find, again, corporations who had worse voting rights, who had weaker voting rights, who had weaker borrowing rights, who had weaker oversight over borrowing, were less likely to pay any dividend at all. Going to market to book ratio, my share price data is a maximum and a minimum every year, essentially. So that's why I construct an upper bound for market to book ratio and a lower bound for the market to book value ratio. And again, what I find is that this is, because these are share prices, it only has to be about public corporations, so there are no private corporations here. And I do find that in my max samples, again, these corporations that had weaker voting rights, right? Either measured as Hills Index or fixed voting scale, worse fixed quorum rules, less oversight over borrowing, these firms tend to have a lower market to book value, whether it's the upper bound or the lower bound, right? So the results are not, you might think that the survival perhaps is a little strange thing, but I disagree. But the results are also robust to like using these other measures. They're not perfect, but I do think that they tell a pretty consistent story about how these rules are translating into these different firm outcomes that are robust across public and private corporations and across these different time periods. Okay, so before we start the Q&A, I just want to give a few concluding remarks here. We've looked at Egypt's legal flexibility here to trace founders' reveal preferences, to find out what sort of rules that they adopted, and really take advantage of this like unusual, like almost experimental setting where there's a repeal after 1908. They have to adopt, found corporations under Egyptian law. And after that, we do find that, constructing a counterfactual British sort of firms that had to incorporate under French laws, that I hope that gave me sort of like this interesting comparison that's able to, address some issues related to selection. The new evidence shows that both legal systems gave weaker voting rights, gave weaker protection in different ways. Okay, this is not monotonic. And in fact, I would think that like they're sort of like converged on these different sets of rules. In the paper, I talk about this a bit more extensively. There's a danger of if you cut the data across different time periods too much, then, you will find out some sort of results. And I do view that as an important point. But for example, during the boom period of 1904 to 1906, these corporations founded under Egyptian law did tend to adopt different voting rules, different borrowing rules. So it looks like, for me, the French system was not necessarily inflexible. The French system, these corporations were doing different things, and they were responding to changing market conditions when they founded their firms. But overall, like if you put a gun to my head and say, okay, Cihan, tell me, like which corporation, which system is worse, I would probably have to say the British one, just because the immense number of rules, like the voting rights and the quorum rules and borrowing, where the British firms just performed worse in those regards. And those are the ones that really mattered for survival and like these other firm outcomes. Although like some of the things that the French were doing were also mattered for the French firms. Okay, so what do I find essentially is that the stronger protection mattered for firm outcomes, for firm survival, for their profitability, and this seems to highlight the sort of agency problems and the dangers of direct entrenchment, especially in a place like Egypt, where it's a developing economy, there's a lot of speculative investments, and where these agency problems could be potentially more severe or a higher order priority. But in terms of like reading through, like thinking through some of the more anecdotal evidence, like I read through Black Economist, other sort of financial press, well, what are they saying? And there does seem to be, before the crisis happened, they didn't seem to care about like which sort of rules that these firms adopted. But after this, crisis happened and the lawsuit started, they seem to find that, oh, wait, like these corporations were actually like doing something like really sketchy with these rules. And so like there is this greater understanding that after 1908, people perhaps started to pay more attention. And so with that, I will stop and, looking forward to your questions and comments.
Thanks very much, Cihan. We have like 3 questions so far in the queue, and I hope that others will join in. Richard Silla asked kind of an informative question, but I will let you ask the question. You might want to add some additional aspects, so please.
Okay, thank you. A very interesting presentation. I'm in New Hampshire, speaking to you, I guess, in Vermont via London and Tel Aviv.
Globalization.
Yeah. My question is, you mentioned that, somehow the financial panic of 1907, which was mainly centered in the United States, caused widespread bankruptcies in Egypt. And I was just wondering, how or why did that happen? What was the mechanism that led this U.S.-centered financial panic to cause the bankruptcies of corporations in Egypt?
Yeah, so this is a sort of like understudied question in a way. I mean, I was like pretty surprised to find it out myself. And I wouldn't go so far to say that the crisis in the US caused the crisis in Egypt per se, but I think they are connected. There's actually a QJE article published in 1911, I think, like an old article that basically argues that this crisis, like these global crises, are connected. I'm not aware of. I think there's a working paper that investigates this hypothesis that the 1907 crisis was global. Anyway, that's a digression. But my view is that essentially the British capital markets were like really constrained. Like the crisis in the US like put pressure on. Like the developing emerging crisis in the US did put pressure in London for London bankers, but also French bankers. So, for example, a book by Roger Owen and Tignor, for example, argue that the French mortgage banks were the first to go sort of haywire, and they stopped extending credit to their branches in Alexandria and Cairo, and that drying up of that capital, that flow of capital in Egypt basically drove people into a panic.
Thank you.
Thank you.
Caroline, for him, you have the next question.
Can you hear me?
Yes.
Hi, Dick. Good to see you.
Caroline. Good to see you too.
Everybody.
I'll hear you.
You can't see me, but you can hear me. Yeah, Amanda and I are working on a similar topic. Go down the hallway.
Yes. I should get her over.
I don't know if she's on here. We're supposed to be doing our own revision. Anyway, but similar topic. So yeah, we should definitely chat. But to Dick's point, the 1907 crisis also hit Germany. I know from my past research on Germany. And also if you look at the paper, like Mark Weidmeyer and Carrie Odell have the paper about the San Francisco earthquake that was in the JEH a while ago. And they talk about the impact of the earthquake insurance company redemptions were largely in London.
Okay.
So that was a big gold drain on London because they had to pay out the indemnity or whatever you call it. The insurance companies were largely based in London. So that had an effect. But also Mary Rogers. Do you know Mary Tone Rogers? I don't know if she's here today. She has a lot of work on the copper core and how copper, and I've actually started working on that too. There was a global problem in the copper industry. And that also fed into the panic of 1907.
Yeah. Yeah, I know that argument.
About the copper, yeah.
Yeah.
And the trust companies, which was also, like the shadow banking of the time, propagated. So even though it wasn't in the banking industry as much, it was in the company.
And I remember that Hilt also with Friedman has together have a paper on shadow banks of all the trusts, right?
Yeah, actually, I just published one in the P&P last year.
Oh, okay, awesome. I'll check it out.
You can look at what the stock prices of the trust companies. Anyway, but point being, it turned into more than just a local panic. But that wasn't my question. Sorry, quickly, it's in the chat. How active were the securities markets? Because this is something that actually Amanda and I are struggling about the differences in the systems, the legal systems. And if the securities markets weren't very active, how do you know the true value, market value of corporations? And likewise, if you have a system that doesn't have a very rigorous accounting standards, and so you're trying to compute book values, how do you know the validity of book values if you don't have audited balance sheets? And I know we all do this, market.
Yeah. No, I hear that. Like I have to do. Yeah, I mean,
I'm asking you the question that has to be asked, even though there isn't a super good answer to it. You always have to ask the question, and you have to, interrogate your sources, as the historians say, or whatever.
Yeah. So no, I take that point. I mean, like at some point, you're free to, take the results with a grain of salt based on like whether the accounting practices and stuff like that. The stock market is quite active. Alexandria is actually like a very, very old stock exchange. There is a lot of sort of investment happening, especially with the founding of the Suez Canal. There are a lot of Europeans. There's a lot of exchange happening. Like the GDP, like the capitalization GDP ratio. Granted, Egypt's GDP is not the greatest, but it is really high. Like it is higher than the French. Like it's higher than France, I think. The stock market is before 1907 is really, really active. After 1907, it just like sort of like it has to close down actually. During the panic, they just say like the stock exchange just shuts down. Okay, you need to stop selling these things. And then the selling continues in the coffee shops outside of the stock exchange. So like the panic is like pretty bad. And so I would say that like I'm not worried about the stock exchange per se. The accounting practices, yes. So like there are all these auditing firms. I know who their auditors are. That's specified in both the British charters and the Egyptian charters. Like these things are audited. Whether like this practice, I can't say to how like reliable the auditing practice is. I can look more into it. I haven't seen like a sort of critique from my reading of the financial press. That might, I mean, absence of evidence is not, that does not mean much, perhaps, but but yeah.
Having auditing and just even having a stipulation of auditing is a relevant piece of, I mean, that's
Yeah. So they had, and they had to specify their auditor. So I can potentially even like have like an auditor fixed effect or something, like because the same auditor comes up quite often.
Cool.
Yep. Thank you.
Interesting.
Christopher Meisner, I'll try to unmute you. I may have done it already.
Yeah, hi.
Hi, Chris.
Hello. So good morning. Thanks for the interesting discussion. Maybe I'm missing some of the subtleties, but what I got out of it is it reminds me a little bit of one of our students here at Davis who studied French and British legal practices in Shanghai in the early 20th century, and just wasn't much difference. And that was kind of like revealed in no difference in property values with the spatial design. And kind of the argument was there's a lot of competition when they're put right side by side. Not to say that there's no difference, but when they're side by side, there's forces for competition. But that was just a thought. Another one is it would really be great to hear like a case study. Like, do you have a couple of these firms in mind that you matched, and to tell the history? And I've been working on international banks, and I know that there's banks from all over the world operating in Egypt at this time. So I'd be interested in how the banks chose their legal status, and how that evolved over time. And we've been talking about the crisis, so that could be an interesting shock. Anyways, thanks a lot for a great talk.
Yeah, thanks so much, Chris. I mean, if you have time, I can tell like an anecdote later after the questions. But yeah, like I've become one with some of these firm histories.
So Nathan Zussman would like to ask a question.
Oh, hello, Cihan.
Hi, Nathan.
Fascinating paper. I have just a question. You might have answered it in the first minute, which I missed because I was late. Is there some selection process in those British firms? That is, like if you're a British entrepreneur, I mean, you can go to the London Stock Exchange or you can go to Alexandria. And so, if Mark Flandreau was here, he would say, it's the main stock exchange or the Colis or some kind of a minor stock exchange where you have a negative selection of firms in some sense. So it doesn't necessarily reflect on the legal origins, or more so, or an interaction with legal origins and the type of people that issue these equities or these assets in Alexandria. And I think again, you in the paper you say that you prefer the regression without the recurrent or repeat founder, but the repeat founder obviously reduces the British origin. So it suggests something of the selection process that's going on. But would you like to comment on this?
Yeah, absolutely, 100% agree. I mean, that's why I do like this arduous task of like trying to like produce these matched samples, right? And so the idea is that like, okay, so the firms might be selecting into British law for many reasons. Some of them could be unobservable. I have no way to deal with that, obviously, but the observable ones, we can sort of deal with it by constructing these matched samples where trying to construct firms, especially after 1908, that would have done what these other British companies doing. Go to the London Stock Exchange, have a higher proportion of British founders, have similar capitalization. And so like I am like issuing stock in the London Stock Exchange is a variable over which I'm trying to I run my variable selection algorithm, right? And that doesn't, that is an important predictor, but it's sort of taken by having British founders is more important to determine whether you're a British firm or not than whether you want to go to the London Stock Exchange. In fact, some Egyptian law companies are also in the London Stock Exchange. I do add that this is a variable that I do control as a covariate as well. And, in some sense, in some variables, in some outcomes, they being listed on the London Stock Exchange does have an effect, but my matched samples, they might suffer from unobservable selection. I fully take that point, but they don't have this problem about selection based on going into the London Stock Exchange.
No, I mean, if I can follow up on this again, I might not understand exactly in the match sample. Okay, so you have firms that would have opted for British law, but now because of the reform, they operate some other law, and they also have higher failure rates and survival rates, etc.
Yep.
So it's not about. So what I'm saying, it's not about the choice necessarily of the legal system, but the stock exchange you want to be listed in that provides the selection mechanism. I mean, that's a little bit different angle. But
okay, I would. There might be miscommunication, but maybe I'm not I was not able to communicate my point, perhaps.
Okay, thank you.
Yeah, but thanks for that point.
Rui, you have a question?
Yeah, I want to piggyback on what Nathan was raising. So for this propensity score match method to be valid, in a sense, you have to verify something is equivalent to an exclusion restriction. Right, so the variables in your first stage should not have a direct impact on your outcome variables in the second stage. Otherwise, you see what the problem is, right? So, for instance, when you include whether the shares are denominated in pounds as a predictor for incorporating in London, one, I don't understand what's the difference between the outcome and the predictor, right? Because there would be I imagine some companies, some British companies would perhaps denominate their shares in local currency or vice versa, but the match there must be almost exact.
Okay.
Right? And in any case, size, age, proportion of investors that are in the market, right? This idea of which is essentially what Nathan was alluding to, this idea of where your market actually is, right? So even if you're a company operating in Egypt, if all of your shareholders are sitting in London, right? What's the point of incorporating there, right? Yes. So I'm having trouble understanding why your predictors verify this implicit exclusion restriction.
I mean, I was basically trying to follow as close as possible don't make any sort of judgment calls about which variable I should include. Just like think about all the observables that can predict. But predict is perhaps like with like high correlates of being a British firm and a high correlates of being like using those essentially to determine how like something that looks like that's the idea, right? We're constructing the sample, and that's the reason that I ran the algorithm. If you have another suggestion, I'm more than happy to like investigate like what's the sort of actionable plan that I can do. If you have a suggestion, I do it.
No, sure. Yeah, I'm happy. I'm actually interested in this type of questions. So I'm happy to talk offline.
Sure.
But for instance, I'm also surprised that you didn't match on industry. Right?
I did, but they dropped out. I did. So that was part of the algorithm. Yes, that was part of the algorithm. They were included. The algorithm did not pick them because essentially they did not improve the information criterion. And the intuition behind that was, well, once you control for the proportion of British founders who are living in Britain, like that takes care of the selection of industry.
Yeah, and very quickly, just 2 more points, right? So you didn't mention self-standing companies because that was a third alternative, right? You could still operate in Egypt without ever being incorporated there, right? And so the Suez Canal company is the obvious example there, right? They were never incorporated in Egypt, and of course,
okay, but it does become operating under Egyptian law later.
Yeah. So in your setting, they didn't have to, and there's all this literature on British.
Sure. But it's also incorporated before Egypt transplanted French law. Like it's an earlier date. My data starts in 1887. Like in order to like essentially get around these like corner cases.
Yeah. So I'm actually asking for information, right? I don't know how prevalent they were. I don't know if the frequency of self-standing companies went up or went down after 1908, right? So whether you're considering those. And then finally, going against everything I was saying, I was struck by how similar the results were between the full sample and the match sample, as if matching didn't matter. Do you have any?
Yeah, in some cases it did, but in some cases it didn't. Yeah, for sure. I think it's just like there's a pretty. I would just say think that some of these British corporations are just very different than the French corporations or like the French. In some cases it did change the results a little bit, like in some of the cases for disclosure of financial information and things like that. And that seems to indicate that there is selection on this especially surrounding the adoption of these questions. Coming back to your comment about the Suez Canal company, before 1887, the formation of business is rather low. The corporations that I can think about are the Alexandria Railway Company or a telegraph company, the Suez Canal. Those are the ones that are founded before, and they are less than they're really a few. I can't remember the number at the top of my head, but I think it's 5.
Okay. Thank you. You need to go and teach, don't you?
Yeah, I need to teach. Sorry.
Thanks.
Okay.
So
Thanks, everyone.
We're running out of time. We have one question in the queue. I have my own couple of questions, but these will have to await another opportunity. I would like to remind you that in 2 weeks' time, November 23rd, we have a paper that will be presented here, Railroads Bailout in the Great Depression. You're all invited to attend. I would like to thank you, Cihan, and all the attendees, and have a good evening.
Thanks, Ron.
Thank you.
Thanks, Cihan.
Good evening.
Thank you, everyone.
Bye.
Bye-bye.